Hi guys, it's Kathy. I hope you're doing well. Is this lawyer going to jail? I mean, the lawyers are supposed to be the ones that don't go to jail. They're supposed to know the law and follow the law. We trust them to follow the law to make sure that they're doing what we need them to do. And when they behave badly, it's not good. It's not good for all the lawyers. Our whole justice system, we have lose faith in it. Let's see if this lawyer's going to go to jail.
Mr. Robert Joseph Andres, that's voted number 55904, a compulsory. Appearances, please.
Judith American Commission for your discipline.
Robert Joseph Andrus, respondent, cause number 55904.
Thank you very much. You may proceed, Ms. Perry.
Please, the board. This is a compulsory disciplinary case based on respondent's conviction for wire fraud in the United States District Court for the District of Utah. We filed a petition for compulsory discipline on March the 12th, 2015, and respondent was personally served with a petition and notice of hearing on March the 6th, 2015 by John Patterson, a private process server. Proof of service has been on file with the board since April the 2nd, 2014. On December the 7th, 2011, respondent was charged by indictment with counts 1 through 5, wire fraud in violation of 18 United States Code Section 1343 in case number 211 CR 00985. Style United States of America versus plaintiff versus Robert Joseph J. Andres, defendant.
Okay, it looks like he is in fact going to jail. Now let's see if he's going to get disbarred as well.
United States District Court for the District of Utah, Central Division. On December the 17th, 2014, a judgment in a criminal case was entered in cause number DUTX 211 CR 00985 001 RJS. Style United States of America versus Robert J. Andres, the United States District Court in Utah. Wherein the respondent pled guilty to count 1 of the indictment, wire fraud in violation of 18 U.S.C. Section 1343, and was committed to the custody of the United States Bureau of Prisons to be imprisoned for a total term of 56 months, and upon release from imprisonment to be on supervised release for a term of 3 years. The respondent was further ordered to pay an assessment of $100 and restitution in the amount of $3,291,310.39. At this time, the commission would offer petitioner's exhibit number 1, which is a certified copy of the indictment filed in the underlying criminal case, a certified copy of the judgment in a criminal case entered in the underlying criminal case, my original affidavit attesting to the fact that the respondent is the same person as the person identified as the defendant.
The only thing that would be better is if he was pro se. Oh, wait.
In the criminal case, and the original certificate of Blake R. Hawthorne, clerk of the Supreme Court, dated April the 8th, 2015, which indicates that the respondent is licensed and authorized to practice law in the state of Texas.
Is that all those are offered as Exhibit 1?
Exhibit 1 through 4.
So each of the ones that you identified was a separate exhibit?
A separate exhibit, yes, sir, I'm
1
sorry.
through 4. Any objection, Mr. Andres?
No objection, Your Honor.
They will be admitted.
Thank you, may I approach?
You may.
Petitioner is seeking a judgment of disbarment in this matter.
Thank you very
Thank
much.
you.
Any questions for Mrs. Baird before we hear from Mr. Andres? Thank you. You may be seated. Mr. Andres, you may proceed.
And what would make it even better if he was pro se and wearing a suit with sneakers, bright white sneakers. Perfect.
I'd like to make a statement. My name is Robert Joseph Andrus. I am an attorney in the state of Texas during the time period involved. During that time period, not acting as an attorney, but acting as a trustee for a Winsome Investment Trust, I was involved in with taking some funds in for participants who were having amounts going through a company called U.S. Ventures LC, which is a limited liability company in Utah, and Robert L. Holloway. During the trial that Mr. Holloway had in Utah in, I think it was the end of July of 2014, I was a witness during that trial, and the prosecutor said I was valued and credible as a witness, and Mr. Holloway, as expressed by the judge, was a sole party doing the things with that.
And object is hearsay at this point.
Go ahead, Mr. Andrus.
Was a sole party that was doing the matters. What I'm saying also is, and I don't have a copy with me, but there was a Novus Technologies lawsuit in 2007 involving Robert L. Holloway and U.S. Ventures LC as a relief defendant. In December of 2010, Mr. Holloway thought he was over and done with the SEC, and then sometime about April 11th of 2007, Mr. Holloway had funds that were frozen. I have in my respondent's response to the petition filed in this matter, there's affidavit attached that Mr. Holloway indicated that he was the sole party, the trust had nothing to do with it, and that he owed over $30 million to the trust. His attorney, Jonathan O. Hafen, also said the same thing, that the trust had no bearing on what U.S. Ventures or Robert L. Holloway did, but he did not attest to the dollar amount because he would not want to do that. The funds that I were told were frozen back in about, I think it was March 30th of 2011, after a civil suit was filed in end of January of 2011 against Robert L. Holloway, U.S. Ventures, Winsome Investment Trust, and myself. They were going after funds that people had put in. There was a deposition, 3 depositions in March of 2011, which I've indicated in my respondent's response, at which I've asked the receiver if he needed any help in going after or retrieving any funds that Mr. Holloway may have lost or diverted somewhere. He said no. I mention that because some of the parties in there who owed some funds were related to Wright Lindsay Jennings law firm in Arkansas. There was an attorney, Elgin Clemens, who was the attorney assigned to me from that law firm to assist me on matters. There were funds that were supposed to be coming forward to assist. He never did. And the receiver failed to go after that law firm also as far as any sort of settlement. It wasn't until March of 2011 when I found out that the funds frozen by the SEC in that collateral matter, Novus Technologies, against U.S. Ventures and Robert L. Holloway, were in fact of a very insignificant dollar amount, probably in the hundreds of dollars, not in any hundreds of thousands or millions as I had expected.
Mr. Andrus, let me stop you for just a moment. I want to give you an opportunity to say what you need to, but let me make sure I understand what occurred here. Did you plead guilty to wire fraud in Utah.
Yes, I did.
And did you receive a prison term of 56 months?
Yes, to begin February 17th of 2015,
That was a few months ago.
3 months ago, 2.5.
Have you served any of that?
In case you're wondering, this was years ago. This video was from years ago. So he has not gone to jail yet.
No.
And can you tell us why?
There's an extension on the court order, the
Report date?
report date.
And what is that extension now?
Right now, it's May 14th of this year, and I expect it and hope that it will be extended.
And can you share with us the reason it's being extended?
Parties are working to get the charges against me modified, and that's primarily what that is. Plus the court in Utah allowed me to finish some matters for some existing clients.
And is it correct that
Oh, that makes me so mad. Other people, normal people, when they get sentenced, they go to jail. Sometimes the judges will give them like a week to get their affairs in order, but they go to jail. And he's not going to jail, and now they're letting him like fight the case and modify the charges. People normally do that in jail, while they're in jail.
in addition to the 56 months, you're supposed to have a supervised release for a term of 3 years after you get out?
That I don't remember, but it's probably correct.
And were you ordered to do restitution in the amount of $3,291,310.39?
Correct.
You may proceed. I just want to make sure you understand what the purpose of today's hearing is, and that is the fact that you have been found guilty of a crime, and allows the state of the commission to come in and seek the discipline that they are. And I don't know if you're trying to, in effect, say, I didn't do it.
No, Your Honor. I did it.
Proceed. May I ask one more question? I apologize for interrupting. Is there an appeal from that conviction?
No, the attorney, the court sentencing date was December 17th of 2014, and before any appeals done, the Christmas holidays and New Year holidays came back or occurred, and when the attorneys got back, I asked what the status was, and they never filed any.
Well, why would there be an appeal? Didn't you plead guilty?
For what the sentence was, that's what the appeal would have been.
So no appeal has been filed. Is the deadline for filing an appeal behind us?
From what I understand, the parties working for me are still trying to get the matter modified.
What do you mean by modified?
I'm hoping that there will not be any incarceration, as the court said, of the panel said.
But my question is, the deadline for filing an appeal to the 10th Circuit United States Court of Appeals has already run, has it not?
From what I understand, absolutely true.
But what do you mean by parties working for you? Is that lawyers, or what does the word parties mean?
I do not have any funds to do anything for myself. I have people who have attorneys that are researching to get the matter modified.
You know, like all of us have. All of us have other attorneys, or people who have other attorneys laying around to get us off cases when we get picked up and charged, so that we don't go to jail.
Does any of that involve trying to get some of this money back?
The cases that I've been trying to work on, some of those do include getting some funds back.
In other words, are you helping the government in any way which could modify your sentence?
Only in the lawsuit did I help them, and there was no, I guess you call it quid pro quo. Nothing like that happened before I gave testimony.
That's the Holloway.
Correct.
If and again, I'm a little confused about what actually is going on here. It sounds like to me there is no appeal, and the time for an appeal to the 10th Circuit has passed. Is that correct?
Through that court period, correct?
And if you're going to get any relief from the judgment, it would have to come from the district court judge? Is that what's happening here?
Yes, Your Honor.
So, again, I'm not sure I have a good idea. I don't know that it matters, but you're hoping to get your prison time reduced or set aside. Is that your goal?
That's the primary one, but in addition, as I put in the respondent's response, I was hoping for a period of time of a few months to try to get the final matters for my clients handled. As one of the witnesses I have, it's been many years that something's been in probate and related matters. Having another attorney step in now would cause problems for them.
Well, that would just be a
And-
deferral of when you start your incarceration, isn't that correct?
Yes, Your Honor.
What I'm trying to understand is whether there would be any potential for the prior plea of guilty to be set aside completely.
That's what I'm hoping for, Your Honor.
And on what basis would you be able to set aside a plea of guilty as opposed to a finding of guilty?
I normally don't practice in criminal law.
Nor do I.
I do not know.
Well, we do, don't we, guys? You pled guilty. You weren't found guilty. You said out loud, I am guilty of this, and then you were convicted. So you can't just say, oh, wait, well, I'm not really guilty. The time for that is over. The only way you can do that is if it's ineffectiveness of counsel, but you're an attorney. So no one is going to believe any of that. You pled guilty. You're not getting this overturned, dude. Nope.
But it's possible that the plea won't go away, but that the period of incarceration would. And one of the things that...
Well, I understand that maybe the amount of time would be reduced, or maybe, I guess it could be taken away completely, but I'm just wondering if the conviction itself would ever be dismissed or changed since you pled guilty.
I don't believe so.
So no matter what happens with these people working in your behalf, there will still be at the end of the day a plea of guilty, a finding of wire fraud. You're just hoping that you don't have any prison time to do. Would that be fair to say?
Well, that's part of it, but I'm also trying to get some restitution for others.
Right. But insofar as you're concerned, the best that you're hoping for with these people working behind for you or whatever is to simply do no jail time.
Well, that's
that
on my
right?
side, but
Right, that's what I'm talking about
For
your
others.
side at this point.
okay.
That's all I'm talking about.
Yeah. For others, we're trying to get some funds back, so.
Anybody have any questions for,
Yeah, you said something about there was only $300 or a few $100s instead of millions missing or something, but you pled guilty to $3 million?
The receiver, R. Wayne Klein, is the one who told me that the funds that were frozen were just probably a few $100s. I'm not sure of the dollar amount because I haven't seen any paperwork, but from what I understand, there was not anything that Robert L. Holloway alluded to. The wire fraud count number 1 was for $25,000. It was sent in by somebody through Utah, where Robert Holloway was located, coming from, or at the request of a party who I did not know, who had the funds put in. But according to the attorneys that I used, I had arranged for loans and and use of funds under power of attorney. Some of those funds that came in, not through this program, but afterwards, I used to pay some participants from the program because I thought funds were frozen. Because that happened, they said it was like a Ponzi scheme. Because it was like a Ponzi scheme, the $3+ million was related to certain parties, even though I did not profit from those. And I did not have anything. It was what they said according to the law. I had asked, would it be better if I didn't try to help anybody? They said yes.
Mr. Andres, earlier there had been a suggestion that it was sort of a permissive decision on the part of the Commission on Lawyer Discipline to seek the compulsory discipline, in other words, allow. I think actually they're required to seek it. That's why it's a compulsory discipline. Are you aware of any rule in Texas or any aspect of the law in Texas whereby we have any discretion to do anything other than grant the petition that the commission has filed? I mean, you've pled guilty to an intentional crime. It's a serious crime, whether it's less than $25,000 or whether it's $3.2 million. I'm looking for any basis in the law of which you're aware for us to do anything other than what the commission has asked.
Unfortunately, I haven't had time. I haven't had time to finish. I called Miss DeBerry and tried to get a 2 or 3 week extension for me to finish that because I had some health problems. And she mentioned that the panel meets every 2 or 3 months. Mm-hmm. So I wasn't able to finish any research. I have not seen anything at this time.
I'm a lawyer, and I'm about to get disbarred, and I don't have time to look for case law to give to the court here? What? And I'm pro se, so that's my job.
I have a question. You have a witness with you today?
Yes, I do.
You've made some representations to us that she would testify about having a civil matter with you that's not completed yet. Is there anything materially other than that representation that she would talk to us about today?
There is an affidavit in my respondent's response which indicates that when I was also picked up on July 3rd of 2012, and at a hearing on July 6, 2012, I was released because they had no witnesses. She happened to be right behind the federal prosecutor and the FBI agent who was a witness, who said that they had no proof that I did anything wrong.
Then why did you plead guilty?
Well, that was, first of all, on the advice of counsel, I pled because the way they explained me using funds after this program was against the way the law was written, and that it was like a Ponzi type scheme, even though it had nothing to do with that program, and I had loans or power of attorney to use funds.
And now that you've made an additional representation of what the witness would say, is there anything else that you would have her talk to the panel about, or do you think you've told us in summary form what that would be?
No, sir, it's in the affidavit. It's
The
nothing else.
affidavit and what you've told us, the witness would not add anything else to the record before us today?
No, the only thing would be that the number of people that I am trying to finalize some legal matters on, which is why I asked for at least maybe a delay in 2 or 3 months, if at all possible.
But that delay, as
all.
I understand it, is for when your imprisonment would begin, is that correct?
I'm sorry?
The delay of 2 or 3 months relates to when you would have to report, is that correct?
Or to finalize the
Haven't you heard him, Judge? He's not going to jail.
matters which the court in Utah allowed me to do, which is why I'm still here.
Anybody else have any further questions for Mr. Andres?
No.
Mr. Andres, we will accept your proffer of what the witness would say, plus the affidavit in lieu of having any testimony. I think there's no need for that based upon what we've heard. Any further questions?
I do have the commission.
Yes.
When would you suggest if we grant reciprocal discipline, that it start, given
Now.
what we've heard this morning?
Now, right now.
I would suggest it start as soon as possible. I would object to certain statements in Ms. Jeffers' affidavit as being hearsay as well, just for the record.
I understand.
I think quite a bit of it actually is hearsay. And also, just as a point of reference, in Mr. Andres' pleading, he represented to the board that I had said that a continuance would not be granted. That's a misrepresentation of what I said. I told him we would oppose any motion for continuance. I just wanted to clarify that point as well.
That's fine. Mr. Johnson, anything further?
He didn't say you said
thank
that, lady.
Anybody else have anything?
No.
Thank you very much. Ms. Berry, do you have anything further you want to add at this point?
I do not.
He said he asked her for a continuance, and she said that of like 2 weeks, and she said they only meet once every 2 or 3 months. He didn't say she denied it.
All right, well, thank you very much. We appreciate your time. We will take the matter under advisement, and we will let you know decisions.
Good news, guys. This was a couple years ago. So, let's look here first. Oh, no, let's look here first. Mr. Robert Joseph Andres was disbarred. In May 4th of 2015. Hold on, I'm missing. I have another thing for you. There. This makes me believe that he did, in fact, serve time in jail and had to pay $3,291,310.39 plus $100. So he is no longer an attorney in Texas. So I wonder, since he's no longer an attorney in Texas, how does he pay back $3,200,000? How does one get a job that pays $3,200,000? Are you allowed to file bankruptcy on a debt that's so huge none of us could ever pay it? Anyway, thanks for coming out, guys. I really, really appreciate it. Just a daytime quickie, and I will see you in my next stream. Bye, guys. Thank you so much.
Got these lights that goes digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Her eyes near a sky so blue. In her jokes there's a truth so true. With each stream she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's love